This is the About the Law channel. I'm attorney Andrew Myers. With me, Yoli. How are you, Yoli?
I'm fine. I'm kind of nervous about this live, but we'll see what happens.
You're nervous? I was just like yelling at intern Red, and so she won't go on with us. That's how nervous I am. She said, you should appreciate me.
Even if we have just one viewer, that's fine, Teresa.
Thank you for joining us, Teresa. Call all your friends. Yeah, Lainey couldn't be with us. Let's be serious now. We're following the Karen Reed case as we did for the entire trial, starting in April and going right to the couple of days before the 4th of July. There was a mistrial, and so they all had to get together and set a date for the new trial. So this is the date upon which they were going to get together and talk about a new trial. Well, as people that are following the case know, a lot's happened since then. Attorneys Yannetti and Jackson have filed a motion to dismiss and a flurry of other documents saying the jury was unanimous on counts 1 and 3, most notably the second-degree murder charge. And so everybody's wondering, is this hearing today going to involve arguments on those motions? Or are they just going to set another date? So there's a lot of drama here, and the hearing is set for 2 o'clock in the afternoon. In case you're watching this later on, it's Monday, July 22nd, 2024 at 2 o'clock. Did I state all that right, Yoli? I'm nervous too. So
what did you say? I'm sorry. I typed in hello.
Oh, okay.
What were you saying, that today is the 22nd? Yes.
Today's the big day. Today's the day they were going to initially decide when the case would be retried. Mm-hmm. But then, since then, attorneys Jackson and Yannetti have filed some motion to dismiss the case based on juror. First, there were 3 jurors, then there were 4, then there were 5 jurors, A, B, C, D, and E, and those jurors comprising, I did my math, 41% of the 12-member panel that did deliberate in the case said we were unanimous on counts 1 and 3, leaving the only one that they were deadlocked on was count 2. Count 2 was the motor vehicle manslaughter while driving under the influence. That was the one that they could not reach a decision on. So a little bit of drama today in Norfolk County Superior Court in Dedham. A little bit of drama here in YouTube world.
Now, I wonder if Alan Jackson is coming out for this hearing.
I wonder if he's coming out for the hearing or if they would enable him to, since it is probably relatively short hearing and he is in Los Angeles, your neck of the woods, would they allow him to appear by Zoom?
Yeah, that's what I'm wondering.
Court call.
Oh, he is doing Zoom, I hear. Teresa is saying he is doing Zoom.
Oh, thank you, Teresa. And so, yeah, I would imagine that. I mean, a lot of times in court, especially since before the pandemic, if you asked a judge if you could appear, telephonically, they would look at you like you had 3 heads or like you were asking for their firstborn. But now
you'd have to get permission and all that. Yeah.
Oh yeah.
Now it's commonplace. I mean, now for status hearing, you just go in by Zoom.
Yeah. Yeah. I remember there was one judge here in Massachusetts. He was out in Waltham and he realized, we attorneys drove from all over the place. We drove for hours, burning up a lot of gas for a pretrial, which often in district court, a pretrial is often 2 minutes, 3 minutes, 5 minutes. Now there are issues, but if you're trying a motor vehicle negligence case or a slip and fall case, and I've done a lot of those, the pretrial, as long as the attorneys are prepared, you have your witness list, your exhibit list, you've condensed down, what the case is about. Your pretrial is only going to be a couple of minutes.
Right.
And so this one judge in the Waltham District Court, which is right on Route 128, not that far from Dedham, said, all right, we'll do it telephonically. And, but most of the judges said, oh, no, I want to see the faces of them. So.
And it used to be that we would want to go into court so the judge could get to know us that kind of thing, put a face to the attorney. But now you can do that through Zoom. So, it's okay.
Yeah, you're right. It was kind of a social thing. I remember back when the 2:00 afternoon motion sessions were seen as a time to see and be seen, and as you say, network with other attorneys.
Mhm.
I remember doing that, but not really so much anymore. I don't know what they do in California, but in Massachusetts, we have a procedure called Superior Court Rule 9A, through which most documents are done in paper, and you send in a package to the court, and then the court either acts on it or rarely schedules a hearing. So
Interesting. Yeah, the courts are closed. LA court is closed today because of that whole CrowdStrike outage.
Really?
Yeah.
Wow.
LA court is closed. I just received an email this morning. So, people who have to file things, I hope they told the statute of limitations if today is the last day to file something.
I remember part of the emergency declarations in my states. I'm licensed in Massachusetts and New Hampshire. And I remember as part of the emergency declarations, they did toll the statutes of limitation for a brief time. I think for a month. In March of 2022, they tolled the statute, which means that if you had a statute running and you needed to file a complaint during a certain period of time, they extended it. So
right. Well, the hearing is starting, I hear.
They had a full minute of just staring at Karen, I guess.
Well, that's what they run in the evening news when they'll write a 45-second story on the news, and that'll be their B-roll. That's what they call it in the news biz. When you write a piece of copy, for TV, you can't just like sit there and go, I'm Joe newscaster, and here's this. No. They have what they call B-roll, which is video that they use to cover the reading of the story. And the reason for that was in the old days.
Good afternoon.
Okay, we got it.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Mr. McLaughlin.
And Your Honor, David Unetti for Karen Reed.
Good afternoon, Mr. Unetti. Good afternoon, Ms. Reed. All right, so the case is scheduled today for trial assignment, and what I'd like to do is to get 3 dates. I'm aware that a motion to dismiss has been filed. I'd like to get a quick date on that, and I'm glad you're here, Mr. Weinberg, because I'd like it to be with your schedule. Then we need a trial date, and we need a final trial. So I was thinking on the motion to dismiss, can we do it a week from Friday? It would be for oral argument only.
From the defendant's perspective, yes, Your Honor.
All right, I think that's August 2nd, Mr. Clerk.
I'm going to be out of state. I return on August 3rd.
Okay. August 9th? Are you available? 2 o'clock. Are you available, Mr. Weinberg, on August 9th? Mr. Lally, is the Commonwealth available on August 9th?
Yes, Your Honor.
All right, so that's for oral argument only, okay?
2 p.m.
2 p.m. All right, so given the schedule, and I assume whatever I end up doing on the motion to dismiss will be appealed. In an effort to make sure we have plenty of time, I would like to schedule the jury trial on January 27th.
But she was going to schedule 3 dates. The motion to dismiss, August 9th. Trial, January 27th.
7th for trial. And let's do the final trial conference the week of the 13th or even the week of the 6th. Do you have the calendar, Mr. Clerk, or any of those days?
Yeah,
Jeez.
just about the 9th or the 16th, but all the days are open.
Your Honor, the only caveat, I don't have anything on the 27th. I'm clear for that day, but for the fact that I have a Superior Court trial scheduled to begin in Essex County on January 13th. There are multiple.
How long do you expect it to take?
That's what I was getting to. That could take longer than 2 weeks. I'm happy to have this case take priority over that, but that's.
No, we'll hold it for you day to day if need be. And I can contact the Essex Superior Court judge once you know who he or she is.
Yeah, that's not ideal. You know, in terms of preparing for trial, I can't do 2 or 3 weeks Superior Court trial and then jump into this case. I can't do that.
Yeah, that's tough for a trial attorney to be trying one case and have the other one hanging over his head. That's untenable.
It's a priority.
No.
Stick with the 27th.
Well, okay. Well, why don't we do this? Let's put it on for the 27th. Let me see if I can make peace in Essex County. And then on the next date, when we come back for oral argument, I can readdress the court on that issue.
Okay, I'm happy to talk to Judge McCarthy, who's the garage up there, about this.
It's yeah, okay, that's great.
All right, so let's set it for the 27th. And why don't we do the 14th for final trial conference?
The 14th at 9 or 2?
2. If it turns out that we have, you know, in excess of 35 or whatever motions eliminates at that point, let us know and we'll try and get them. Okay. All right.
Thank you.
All eyes for 4 please.
All right, I'm going to pull the plug on this. I turned my headphone volume up so that I could hear it, but I'm going to pull the plug on it. Lenny, can we get rid of this? Great, thank you. Okay, Yoli, did you hear all of that? I took notes.
I heard, yes. What I guess she's doing is she's setting the motions to dismiss the motion to dismiss in August.
Yep, I got the dates right here. The motion to dismiss oral arguments will be held on August 9th at 2 p.m. The trial, she is dead set on scheduling it for January 27th. And when David Iannetti says he has another trial in Essex County, which for those of you not in Massachusetts, that's north of Boston. Dedham and Norfolk County are south and actually more to the west, Dedham being more to the west of Boston. And then, so the trial date, the judge was really dead set on scheduling this for January 27th. And the final trial conference, I call it a pretrial conference, but it's been pre-tried. So the final trial conference is set up for January 14th of 2:00. So you're a trial attorney. Do you want this hanging over your head over the holidays?
It's just, you know, and she said that most likely, well, she said that her whatever she decides on the motion to dismiss, that they're going to appeal it. So she wanted to give enough time for the trial to start. I don't know if she meant an interlocutory appeal, like we talked before, where they appeal right after, you know, while the case is pending, meaning the trial date's pending. It just seems so sad. And she seems dead set on it. I mean, I guess she's just going through the motions, but you know, with the evidence that they have that I've seen, and I haven't seen everything, just doesn't seem right.
No, it really doesn't. And the other thing is, in Massachusetts, an appeal takes longer than that. I mean, if the motion to dismiss is heard on August 9th, even if she decides in August, September, October, November, December, January, appeals don't happen that quickly. Although, you know, I do know in the Koberger case, they kind of pushed it. And in other cases, they do push these things. But I mean, that's awful fast, especially since there are 2 levels of appeal beyond the Superior Court. From Superior Court, an appeal is taken to the Massachusetts Court of Appeals in that building behind us, actually to the right of us. And then after the Massachusetts Court of Appeals is the Massachusetts Supreme Judicial Court in the same building next door, up in one of the top floors. And so to see that it would happen within that short period of time, I'm not saying it can't happen, but it's unusual. It's very unusual. I've done appeals, and you you need time to brief.
Right.
You need time to brief.
Yeah, and Daria is asking, what are the compelling pieces of evidence for you that you see? And I don't see any compelling evidence that she intended to unalive him. But I, at least from what I saw was just barely enough to meet more likely than not, which is not the burden. The burden of proof is beyond a reasonable doubt. And I barely saw, like when they were saying consistent with, I barely saw evidence that was, more likely than not. But even that, I don't know. I mean, we had bias with Proctor and his texts calling her a psycho. We had, blood in those Solo red cups.
Don't forget the leaf blower. Don't forget the leaf blower.
We had a guy throwing away his phone when he was told not to. Higgins. And
we had all those texts, those bizarre texts between Karen Reed and Brian Higgins. Oh, I think you're hot. Oh, the feeling's mutual.
So bizarre. And then her fight with him in Aruba, like, what is that?
Well, the Commonwealth was making an attempt there. They were making an attempt to show motive that apparently, and it was played up a lot more in the press than the way it came across at trial. If you're just going by the trial testimony, John was having a few drinks, we'll say, and he bumped into this girl, and she steadied him and guided him to the bar. Now, whether you believe that or not, I'm just telling you the story, because the way it was kind of played up, if you read the local media, was that he was making out with the woman. And again, this alleged, was in the press, comment all you want, but the media was trying to say that John O'Keefe was making out with this girl, and Karen saw it, and so she was outraged, just totally outraged. So the trial had a lot of ins and outs. And remember, we did that episode with Susan Constantine, the jury consultant, and she said, they've really got to hone down the evidence. They've got to hone it down, and what is relevant, what isn't relevant. What are the elements? There are 3 charges. There's second-degree murder, there's motor vehicle manslaughter, and there's leaving the scene of a collision. There are 3 indictments, and they've got to look at what the elements are of each, break them down, determine what evidence is absolutely positively required to fill all of the buckets that make up those elements, and just do that. But this
70 witnesses.
74 witnesses, 600 pieces of evidence.
74 witnesses. To prove, come on. 74 witnesses. That's like overkill and this isn't even a complicated case. They're trying to say she backed into him and intended to unalive him.
And look, Teresa's telling us we forgot something. We forgot about the Stop and Shop bags.
Oh,
Thank you for reminding us, Teresa. The Stop and Shop bags into which they placed the Solo cups. Which, it's funny. I think about this case I do my own grocery shopping, and every week I go down the aisle where the Solo cups are. My head.
The FBI investigation is going on into Proctor, and I don't know. When the outcome of that comes out, I don't know if that will have any effect on the charges being dismissed. I don't know. I think it should, but I don't know for sure. Not with this court.
I'll make a prediction, and I'll put money on it. Not a lot. I'll make a prediction that just by the way the court was addressing the substantive matter about the August 9th hearing on the motion to dismiss, I will make a prediction that she will deny the motion to dismiss. Do you want to take me up on that bet?
No, I think she's going to deny it. And I don't want to say anything bad, but I think she may have already made up her mind because she's had a chance to look at everything, the affidavits from the juror and the affidavits from the attorneys about the contact. And I think that she doesn't seem concerned at all.
No, I think she is going to go with the language that the Norfolk County Assistant District Attorney Alan Lally placed in his motion when he opposed the motions to dismiss. And I quote from the motion, Lally's contention is that it is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. So that was the Norfolk County District Attorney's position. She will go with that. The defense will take it up on appeal, and we will see whether the two levels of appeals will go ahead and reverse her decision.
Yeah, and it just seems so lengthy. And I mean, it's one of these things where if maybe things had been done, it's always hindsight. If maybe she had just asked for them to give their findings on each count, maybe things could have been different, but it didn't happen that way. And, hindsight's 2020. And I don't want to think that this judge just, completely just ignored her rights. But at the same time, I'm going to be interested in what this appeal or the motion to dismiss hearing. I'm going to see if I can make time to watch that or be on live with that.
Yeah. Now, there's something that's a little bit new, although it was in the background before. Netflix says it is going to do a 3-part documentary on this case. Netflix has announced that it is currently in production with Sandpaper Films, with co-director Danielle Johnson and Rob Miller. They issued a release that says the team feels immensely privileged to be bringing this important series to a Netflix global audience. Johnson and Miller told Netflix it's a case, well, we knew this already. We didn't need them to tell us that, quote, it is a case that has garnished a huge amount of public attention and has far-reaching implications. We are also mindful that this is a hugely sensitive case, and we are determined to treat all those involved with the respect and consideration they deserve. So here's my question, as somebody that used to be in the communications business. Do they go full force ahead, or do they wait until the end of trial 2, if indeed there's going to be trial 2?
Well, lately they've been, there's docu-series or documentaries on cases that haven't even gone to trial yet, like Koberger. They did a docu-series on that. I don't know. Yeah. I mean, I don't know what they will do. Maybe they'll do a part 1 series, a docu-series, and then a part 2 when the trial is done, or...
Oh, yeah, that could be, because it says right here that it's going to be a 3-part documentary. So you're right. Maybe. And also, one of the other things I read about the Netflix series that is to be done, they said they were going to concentrate on the 3 weeks before John O'Keefe's demise. They said it was going to focus on that. So I guess a lot of things happen. They might, dramatize what happened in Aruba. They might dramatize, these fights that they had. They might dramatize, Higgins's and her. I can just see it now, like a Lifetime type of a movie where, maybe there was something between them. I don't know, but I've watched enough Hollywood to know that they could dramatize, Higgins, texting her and saying, hey, let's do this, let's do that. Apparently there was a kiss that was exchanged outside of where the cameras were. I mean, I don't know. I really don't know.
I don't know. And, if you really think about it, none of that proves that she did it, she actually did it with the intent. I mean, Higgins threw away his phone after he was told not to. Why?
Because there was some stuff on there he didn't want. Why else would you throw it out unless there was some stuff on there you didn't want to go out? I mean, come on. It's just,
why
the
would
whole
you
thing
do
is... But no, you're right, because I have watched docuseries here and there, and they are done before trial. And then in the after notes, they roll the credits in the after. They say, Yoli Medina was tried on, August 27th of 2024, and she was found guilty. They'll run that in the end. So I guess that's a possibility. I don't know. I mean, if you're in the entertainment business, it's money. It's all about money, money, money. So they would want to strike while the iron is hot, I would think. I think they would want to produce this, while the American public, which is very fickle, as you and I both know, I think they would want to produce it and get it out there while people are still thinking about this case, because 6 months from now, 12 months from now, they will have forgotten all about it, I would think. I don't know.
And if you have to have 70, how many, 76 or 74 witnesses?
Yeah.
If you have to have so many witnesses to prove your case, it seems like they're grasping at straws.
And the two women that were there on the trip to Aruba, in retrospect, was their testimony really necessary? I mean, I think
prejudicial.
I
think it's more prejudicial than probative, because it can cause the jury to think of her as a nasty person because they claim that she called one of the ladies a name. And it's just, while it might have something to show motive, but it's more prejudicial than probative. So, it's one thing. Yeah.
Teresa just said every couple argues doesn't mean you're a murderer. And I agree.
No.
I mean, I agree. Who amongst us doesn't know somebody that was in a toxic relationship, or a relationship that was good for a time and then broke down, and there were arguments, there were disputes, there were disagreements amongst, things that got increasingly important, and then they finally decide to break up and they go their separate ways. And this happens sadly all the time, and they don't kill each other. So
No.
I just don't.
And I guess another juror was interviewed, a sixth juror, I guess.
I see that. Yeah.
Yeah. I wonder.
We will track that down for the next episode. There was a little lesson in internet stuff. There was a creator who has a lot more experience than I'll give him that. There was a creator who's an attorney who simply asked a question last week with respect to this hearing today, with all these motions to dismiss, and the affidavits by Attorney Jackson and Attorney Yannetti. Now, they actually spoke to jurors. The jurors called them. They didn't call the jurors called them. And so Yannetti and Jackson, spoke to them and did their affidavits. And this hearing today was coming up. And this creator said, well, should Beverly Cannone be the attorney? Should they remove her? And so it's like that game telephone when you're a little kid. That was passed on, that was passed on, that was passed on. Commenters and other sites were saying, I heard that Judge Cannone is going to be replaced. And then we got comments. Didn't you hear us? So we were wrong and we didn't know what we were talking about. Didn't you hear Judge Cannone has been replaced on that hearing next week? And I kept going on to the docket as recently as the morning before we're doing this live. I went on the docket, and you can go to the hearings and the assignments. All attorneys do that. You can go on the Massachusetts court site. I have a hearing tomorrow in Essex County or Worcester County. I can go on there and see who is the judge that's assigned. And I went on last week when I heard these internet rumors with this other creator who's an attorney saying, well, she should be replaced. And then it got to the point where, don't you know she's been replaced?
Yeah.
So I kept going on the doc. I kept going on that. Her name was there. Her name was there. Her name was there. And as recently as this morning, I don't know, 10:30, I went on the docket and her name was there.
Yeah.
So, I mean, it's just,
and I've even gotten confused with reporters in Boston saying that there were new filings when there really weren't new filings.
No. Well, I think the problem is, I was a reporter, and we tried to do our best. But we weren't attorneys. Now, there's some really good reporters in Boston. I know one of them. I'm not going to name him, but he helped us with an episode that we did a long time ago on the Adam Montgomery case. He came on and he helped us. He does his research. He's won 11 Emmys. And he does. This is his specialty area: crime, law and order, the courts. He does a series that is all about Massachusetts Most Wanted. So he's a specialty reporter. So he knows his stuff, and he knows the difference between a motion and an objection and an affidavit. But you know what? A lot of people don't. I mean, if they're covering a fire 1 minute, a beauty pageant the next, and the governor swearing in an executive counselor the next. It's a tough job. Being a reporter is a tough job. I used to do it, so I'm not really defending the fact that they misreported it. But if you're a general assignment reporter, you can't know everything there is to know about everything. You don't know about the design of a bridge that collapsed in Baltimore. You don't know about what goes into the determination of a fire, and you don't know the difference between a motion and an objection. Sad but true. But anyhow, so I just thought I'd point out that rumors spread on the internet. The internet's great. I was having this conversation with Red, who couldn't be with us this afternoon earlier, that we both agree that the internet's a great resource. It's really a good resource because a paper that used to take me weeks to write for the research, you can write it in an afternoon now because the research is right there. But you got to be careful because there's a lot of bunk on the internet.
Yeah, and YouTube.
I love YouTube. We love YouTube. We think it's great. YouTube. We think it's wonderful.
But there's a lot of stuff out there that isn't. It's people's opinion, and people's opinion just gets turned into a fact, and next thing you know, you have rumors. So yeah, you're right. I mean, it's a little. You have to be careful. And
Teresa asked me a question. Andrew, why do judges get to decide whether they should recuse themselves when defense makes a motion? Well, I mean, they have ethical standards, unlike the U.S. Supreme Court. There are, in Massachusetts and New Hampshire, where I practice, there are ethical guidelines and rules and conflicts of interest. And it is up to the judge ultimately, but I think that a lot of judges there are a lot of judges in Massachusetts, must be in California too. So I think they meet, I think they conference, I think they work together. And I think, generally speaking, they do a pretty good job deciding when they have a conflict of interest. I mean, I've tried cases in front of a judge that held a little conference beforehand. We come on up to the bench. This attorney on the other side, and I worked together at a big law firm, Dewey, Cheatham and Howe down in downtown Boston. And I was in this division and he was in that division, and we had nothing to do with each other. But I need to tell you that before we try the case, Attorney Myers, I will give you the option of trying this a different day in front of a different judge. And I said, no, we're good. I mean, because those big firms are like that. I worked for a smaller firm where we knew everybody pretty well. But that's true in some of those big firms. In some of those big firms where they have hundreds of attorneys in skyscrapers, a person that's in the blue sky division isn't necessarily going to know somebody that's in the bankruptcy appellate division. You know what I mean?
Yeah.
Anywho, I don't know.
We'll have to see what happens.
Yeah. So we'll follow this. We'll keep looking at it. We'll keep going. We want to thank Lainey Law, who had her tonsils out and she can't speak, but she's helping us. She's behind the scenes, moderating and helping and doing everything that needs to be done, because I could never do this by myself. And Red scattered because I think I was like yelling and screaming and being nervous. And then she said, "You have to appreciate me."
Yeah. Well, this was a nice little live. I mean, it was short.
Yeah. So,
And,
the one that'll be more interesting, and I think we should do a live for that one, will be the one on August 9th. So, Lainey, put that in your book, August 9th.
Okay, I'll put that in. I just want to say that I give you a pass for the next 110 technical issues you have, because we got through it, but that was so funny, especially the fact that was such a small, short video. Oh my God, by the time we got it working, it was over.
So I guess we'll wrap it up. Lainey, stay on after we wrap it up, because I want to ask you a question.
Okie dokie. Yeah, thank you guys so much for watching. Andrew, what do you got to tell them?
What am I going to tell them? I'm going to tell them, be nasty, be mean.
no.
Blame us in the comments.
Well, I'm reading the comments on the episode that we just did with Lucky. What a fantastic guy that guy is. He's so bright. He's so smart. And the comments we got from that episode kind of epitomize what I always say. Please be kind, be respectful, whether you're in the grocery store or the gas station. You don't know what the other person's going through. So we all, whether we disagree or we agree, and we don't always agree. We just, we don't always agree, but respect the other person. And the reason I brought Lucky into it is because he's popular. People love him. People really like him. They see him for somebody that, as he puts it, he breaks it down, makes it understand. Sometimes attorneys like Yoli and I tend to, go way off into the ether.
We're talking about things that other people just are like, what?
But even so, most of the people loved Lucky. They said he was great. Have him on again. Your panel. We love your panelists, but he's really good. But I had one comment out of all the great ones, out of all the one commenter just really blasted. I don't like that. Delete. Because it's there's no need for. You can tell me you don't agree with me, and the reason I don't agree with you is because X, Y, or Z. Or I didn't agree with what Lucky said because I've read and done my research and found otherwise. That's fine. But if you just kind of really go off on him or me or Yoli or anybody else, there's no call for it. There's no need for it. And your point of view would be left on the comments and respected and read. But once you start personalizing, it's just a waste of everybody's time. End of rant. End of rant.
End of rant. Thank you guys so much for tuning into our live. Be sure to comment on this if you enjoyed it, especially if you missed it live. And we hope to see you guys again soon. Thank you.
You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts, and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertising.
And that's that.
And that's
that.
Bye, everyone.
I'm declaring a mistrial in this case.
She's a whack job.
And yesterday, during the entirety of your questioning by Mr. Lau, not once did you mention that this video is actually completely inverted.
I did not know.